cause numbers 25 DCCR 0974 and 25 DCCR 1152. Mr. Torin was previously in court, entered pleas of guilty to attempt to commit theft of property. It was enhanced to a second degree because of priors, and then evading arrest or detention with the vehicle, also enhanced to a second degree. I've received the pre-sentence report, and the agreement was for a cap of 20 years. It looks like it probably could have been habitual, but you guys pled it to just a straight second degree with an open plea to the second, correct?
Yes, ma'am.
And I've received the pre-sentence report as well as some documents that Mr. Radford has sent in with regard to Mr. Torin's mental health, as well as some physical issues, and one letter as well of support. Have you both had an opportunity to review all of that?
Yes, ma'am.
Yes, Judge.
Are there any additions or corrections to that pre-sentence report?
Just the things that I submitted, Judge.
Okay, Mr. Radford, you may proceed.
Judge, Mr. Torin has an extensive criminal history. However, as he has gotten older, he has had some health issues. He has vision problems. He has been seen and treated at Spinaltop MHMR for some mental health issues. He has a very supportive family who is here today, and I'd ask that the court take that into consideration in determining his sentence.
What is the status of parole?
No, waiting on the
We're on this.
Okay.
Mr. Smith?
Judge, his extensive criminal history going all the way back to his juvenile years tends to show more about what he is and what he does than anything else. He's been given probation. He wasn't able to complete that. He has been sentenced to multiple long sentences in prison, and that seems to be the only thing that has kept him from committing new crimes in society, was the fact that he was incarcerated. I don't feel like probation is appropriate. We would ask for, we have given him consideration by coming off of the habitual and capped this at 20 years. So we would ask for a TDC sentence in the high range on this.
So, Mr. Torin, in 2019, you received a 15-year sentence. So you were only not, I don't know how long it doesn't show me when you got out or how long you were in on that, but obviously.
I got out one night of 23.
So you got out in 2023, and less than 2 years later, you've got 2 more felonies, which add up to your 11th and 12th felony offense.
Before the judge moves into the details of what actually happened on that highway, there is important legal context that explains exactly how this sentencing arrived at the number 20 and why that number represents something more complicated than it might first appear. Mr. Torin pleaded guilty to 2 separate charges: attempted theft of property and evading arrest or detention using a vehicle. Both of these charges were enhanced to second-degree felonies because of his extensive prior criminal record. Now here is the part that matters enormously. The prosecutor pointed out directly in this hearing that given the full scope of his criminal history, this case could realistically have been pursued under a habitual offender enhancement. And in Texas, a habitual offender enhancement can dramatically increase the available sentencing range, potentially exposing a defendant to a minimum sentence far higher than what is being discussed here today. Instead, the state made a deliberate decision to keep this case at a straight second-degree felony level with an open plea capped at 20 years. The prosecutor explicitly described this as consideration being extended to this defendant, meaning the state already chose not to pursue the maximum legal exposure available to them. What happens for the rest of this hearing is the judge deciding where within that already reduced range of 0 to 20 years this particular case actually belongs.
And I understand the issues with PCP
Listen very carefully to the simple math the judge just laid out, because in just a few sentences it tells you almost everything you need to know about the trajectory of this case and why the conversation in this courtroom is unfolding the way it is. In 2019, this man received a 15-year sentence in the Texas Department of Corrections. He was released from that sentence in 2023. And in less than 2 years after walking out of prison, while still on parole from that very same sentence, he picked up 2 brand new felony charges. Not his second offense ever. Not his fifth. These 2 new cases bring his total felony count to his 11th and 12th convictions. 11 and 12. For a man who had just been given the opportunity to return to society after serving a significant portion of a 15-year sentence and who chose, within less than 24 months of freedom, to commit the exact kind of behavior that landed him back in a courtroom facing another 2 decades behind bars.
It looks to me like that's more of an issue than anything else. I understand there's some mental health issues, but you, as a grown man, have had every opportunity to get help and try to get in TDC, out of TDC, to live your life outside of prison, and you've chosen not to do that.
Right here, the judge references something specific from the substance abuse assessment that was conducted as part of this pre-sentence investigation, and it is doing an enormous amount of work in shaping the outcome of this sentencing. According to this defendant's own words, spoken directly to the professional who conducted that assessment, the only time he has ever been clean from drugs is when he is in custody. Sit with that for a moment. This is not the judge's interpretation of his behavior. This is not the prosecutor constructing an argument about his character. This is Mr. Toren's own description, in his own words, of his relationship with sobriety throughout his entire adult life. When a defendant tells the court directly and voluntarily that incarceration is the only environment in which he has ever managed to stay sober, that statement becomes part of the official record the judge must weigh when determining what sentence actually serves the dual purpose of addressing this individual's circumstances while also protecting the broader community going forward.
I mean, your only time clean is when you're in custody. That's what you told the person doing that substance abuse assessment.
And right here, the judge stops discussing criminal history in the abstract and shifts into describing, in specific and genuinely frightening detail, exactly what happened during this evading charge that brought this case to this courtroom in the first place. He almost struck another vehicle at the intersection of Interstate 10 and 7th Street. Then, he almost struck a second vehicle at the intersection of 7th Street and Dollinger. He then crashed through a fence. And instead of stopping at that point, he continued fleeing after that crash. He crashed again. And only after all of that did law enforcement finally take him into custody. This was not someone who briefly failed to pull over and then quickly complied. This was a sustained, high-speed pursuit through multiple intersections, with 2 separate near misses involving other drivers who had no idea that morning that they were about to become part of a felony evading case simply because they happened to be on the road at the wrong moment. What do you think a sentence should reflect when the danger to completely uninvolved members of the public was this immediate, this repeated, and this real?
I don't know. I just think it's such a... I appreciate your family being here, and I appreciate the support, and I appreciate this letter, but it's all ridiculous when you look at your criminal history. And the fact that you're on parole and you commit 2 more offenses and you're still using drugs and you haven't made, it's not like you're a young kid. You know what you need to do to get the help you need to get. And you've made a conscious decision not to do that. So at this time, in cause number 25 DCCR 0794, and this evading was crazy. I mean, you could have killed people. You got used, I think it was twice you almost struck intersection of Interstate 10 and 7th Street, almost struck another vehicle. And then again at 7th Street and Dollinger, you almost struck another vehicle. You crashed through a fence. Then you continued to flee after you crashed through a fence and crashed again and finally came to arrest. I mean, it's not like you just kind of sort of evaded. Your behavior is just a danger to everybody here in Jefferson County. So that being said, 25 DCCR 0794, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time, the Institutional Division of the Texas Department of Corrections. And cause number 25 DCCR 1152, find also sufficient evidence to find you guilty, and at this time, find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true, sentence you in accordance with your agreement to a term of 20 years in the Institutional Division of the Texas Department of Correction. You will receive credit on each of these sentences for any time that you've been in custody that the law gives you the right to receive. I'm handing you, and they will run concurrently, which means together at the same time. I've handed you the trial court certification that shows these were agreements. I followed. You've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. Read that. You should already understand it. But if you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Radford. All right, you can go back.